morning, everyone. Today is March 10th, 2022, and welcome to the New Possibilities Hour, part of the Will Work for Food project, organized by Natalie Armstrong Motan in the spring of 2020. Every Thursday morning, Jean Lawler and I are very proud to host another wonderful cutting-edge webinar related to negotiation, mediation, arbitration, and lawyering. There's no charge for these great webinars. Rather, we ask you to contribute to a food bank if you like what you see. And every week, one of my favorite parts of the program is when we announce the running total of the contributions our generous audiences have made, contributions of which we're aware.
This week's total of known donations to food banks around the world is $251,812. Thank you all so much for your generosity. Really, really impressive.
Wow. When we started this, I think we had no idea that people would be motivated to contribute over $250,000 to fight food insecurity worldwide in honor of the great speakers who have agreed to volunteer their time for the Will Work for Food project. It's just extraordinary. Well, today we have another extraordinary presentation for you. We have Thomas Weathers. He's a past president of the National Native American Bar Association, and he's going to be talking to us about Native American dispute resolution. We take diversity seriously around here, and we view it broadly, and we want to present a broad range of perspectives and a broad range of ideas. And I know that Thomas Weathers is going to contribute to that in a significant way. We know that Indian tribes are unique. They have their own history, their own sovereignty, their own court systems, and their own ways of resolving disputes. And nobody's more qualified than Thomas Eagle Weathers to present that to us. Mr. Weathers is an Aleut and an enrolled member of the Qawalangin Tribe of Unalaska in Alaska. Mr. Weathers is the principal and owner of the law offices of Thomas Eagle Weathers, PC, where he practices Indian law, business law, and related litigation. He's also of counsel to Monty White LLP, a well-regarded full-service law firm located in San Rafael, California. Mr. Weathers has practiced law for almost 30 years. He advises and litigates on behalf of tribal and non-tribal clients on a range of matters, including contracts, torts, governance, economic development, gaming, finance, taxation, land use, real estate, eminent domain, leasing, rights of way, commercial ventures, administrative law, insurance, energy development, construction, cannabis, transportation, employment, personnel, housing, code drafting, and Indian child welfare. Mr. Weathers has served as general counsel to several Indian tribes. He's negotiated hundreds of agreements worth millions and millions of dollars, dealing with all of the subjects listed above. He has also helped clients restructure substantial debt, renegotiate loans in default, obtain complex financing, and realize economic development opportunities. What extensive corporate and litigation expertise. Thomas Weathers, we're so happy that you're here with us today to share your wisdom. Please tell us a little bit about the food bank that's important to you, where you'd like people to direct contributions if they're in a position to do so. And then please educate us about Native American dispute resolution. The floor is yours.
Thank you, Jeff. I'm honored to be here. The San Francisco Marin County Food Bank. If you can donate there, that would be great. I've done some volunteer work with the Marin County Food Bank, and yes, there is food insecurity even here in the very affluent San Francisco Bay Area. Thank you for that introduction. Kila Echamna, which is good morning in Aleut. So I'm Aleut. So if you look at Alaska, you know there's that tail that comes out. If you go way out in the middle, there's an island called Unalaska, and that's where all my family comes from. I'm the first one that was born outside of Alaska. I was born in Southern California, but my dad and grandpa and everyone else was born up there in Alaska. So I'm a member of an Indian tribe. It's called the Qawalangin Tribe. Technically, it's not an Indian tribe because in Alaska, we have Aleut, Eskimo, and Indians. Those are what we call Alaska Natives. And then in the lower 48 states, we have Indians. And I'll get into that in the presentation. Jeff mentioned all the different things I do in Indian law. I'm kind of a jack of all trades in a way, because I represent tribal governments, tribal corporations, tribal individuals, and you end up doing everything from family law to probate to contracts to gaming and finance. Cannabis and hemp have been big in the last few years. So you really do, it's a great practice area because you do a lot of different things. And as we get into the presentation, it's also a great practice area because Natives approach dispute resolution differently than Western culture or Anglo-American culture. And for me, not having been raised on a reservation, it's been great to learn that traditional way of resolving disputes versus the Western trained way I've been taught through law school. So I'll get into this as we go through it. The key point in Indian law really is that in the United States, there's three sovereigns. There's the federal government, the state government, and the tribal government. And I think people forget about the tribal government sometimes, but it's a relatively equal sovereign to the states. And I'll discuss that some more. And really what Indian law is, it's kind of the intersection between the feds, the states, and the tribes. And then who can tax, who has jurisdiction, whose probate laws apply, whose land use laws apply, things like that. So it's a fascinating area to practice. It runs the gamut from A to Z on what you can do. And then also, I'm a part-time tribal court judge, and I'll discuss that a little bit later too, but I serve mostly as an appellate judge for different tribes, both on an intertribal court and then a specific Supreme Courts for various tribes. And again, as a separate sovereign, it would have its own court system, just like the state of California where I am, or the United States, or the country of France, or whatever would have its own court systems. So Indian law, and as we go through, I guess if you have questions, we're going to do those at the end, Jeff?
As you wish, Tom.
Yeah, or it's probably better to do them at the end. I usually get a lot of different questions on a lot of different things. The first question I always get when I start these presentations is, what's the right term to use? You've heard Indian, you've heard Native American, you've heard American Indian. Really, to me, it doesn't matter. And I think to a lot of Natives, it doesn't matter. The US Constitution actually refers to the word Indian. And I put it up there on the screen in the Indian Commerce Clause, that the Congress shall have the power to regulate commerce with the foreign nations and amongst the several states and with the Indian tribes. And think about that for a second. When this Constitution was written in, 1787, the United States viewed Indian tribes basically the same as foreign nations. We were sovereign powers. And then over time, we got conquered. But so tribes kind of have this unique status under American law and how it interacts with the states and the federal government. But you can use the term Native American. It came into vogue in the 70s, really to encompass more the Aleut and the Eskimos as well as the Indians. Or you can use Indian. It's really your preference what you want to do. And then I always throw in this little trivia question. You know, Kamala Harris is our vice president now in the United States. And I've heard news outlets say, oh, first vice president of color. This is wonderful. Well, actually, it's not true. The United States had a vice president of color, and it was Charles Curtis. And he was a member of the Kaw Nation, which is in Kansas. And he was the vice president to Herbert Hoover. So Kamala Harris is the first, say, female vice president or vice president of South Asian descent. But technically, she's not the first vice president of color. So I always like to throw in a little trivia about that. I just put up a picture here. I like to show people what is an Indian. And I get it all the time too, because I look like a white guy. The stereotype of, well, an Indian should look like Pocahontas or the emblem on the former Washington Redskins helmet. But natives come in all shapes and sizes, and tall and short and big and small. So you can't really judge a book by its cover. And being native it's a racial classification, but it's also a political classification. And that'll get complicated in Indian law, but it's how you can set up special laws for tribes and tribal kids and tribal members, because the government views them as citizens of a different domestic dependent nation, i.e. Indian tribes. And so there's this political component to being Native as much as there's a racial component to being Native. So keep that in mind. You know, the stereotype that's going to pop in everybody's head is the, you know, the feathers or the tomahawk, but that's just not the case anymore. There's Natives in all walks of life. And we come in all different shades and colors and whatnot. And I'll pass this along as just a tip from me personally. The most annoying question I get when I say that I practice Indian law or I'm a member of an Indian tribe is, oh, well, how much Indian are you? But ask yourself why you would ask that question. You don't go up to an Asian person and say, how much Asian are you? Or a Jewish person, how much Jewish are you? It's kind of it's a racial affront in a way. And a lot of Natives, to me, that's a racist comment because you wouldn't ask that of other peoples. And I can get into the history, but that whole concept was created by the United States government back in the 1850s to separate full-blooded Natives from half-bloods and quarter-blood Natives. And it was a way of dividing and then ultimately assimilating all of the Indians in the country. So the question itself has racial underpinnings that date back 150 years or so. So just keep that in mind, that when you think of Native, don't necessarily think of these stereotype kind of racist images that we see in public media. Who's an Indian? Who's a Native? There's no single definition out there. Most people agree that it's really somebody whose ancestors lived in North America before 1492. Why is that date important? Because that's when Columbus first discovered North America. And so that tends to be the date. So if you've had ancestors living here pre-1492 and you're either recognized as a member of your tribe, either the federal government will recognize you, there's certain federal statutes, or your own tribe can enroll you as a member or a citizen, or you participate in different events with the tribe or whatnot. So those are kind of the measures to be a Native. Again, the whole blood quantum thing, it differs per tribe. Each tribe can decide its own membership. And so some tribes say you've got to be a quarter blood or a half blood or an eighth blood. Most tribes, including mine, say you just have to have a lineal descent from someone who was here in 1492. And what happened, quick aside, the government went around 1900 and they did a bunch of rolls and they took a census of what Natives were living where. And so usually if you can trace a relative, great-grandmother, great-grandfather back to that roll, and then you come down the lineal descent, the tribe will enroll you as a member. So each tribe decides its own membership. Most of them do it just on your lineal descent from one of these rolls. And I always ask the Tiger Woods question because you ask people, I'm sorry. Oh, Tiger Woods question, you know, the famous golfer. People, what is Tiger Woods? Most people are going to say, oh, he's that black golfer. Well, it turns out that's not true. Tiger Woods is half Asian. He's only an eighth black, and he's actually an eighth Native American too. And then he's a quarter white. But it's funny how you look at Tiger Woods, go, oh, he's the black golfer. Or even Barack Obama, the president. Oh, he's the black president. Well, he was half white too. So be careful of that whole slippery slope with blood quantums and how much Native you are or how much Native you're not. It's really up to you and your tribe to decide who's a Native and who's not. It's not for the world at large to tell you you are or you are not a Native. And keep in mind, throughout the last 200-300 years, well, really since 1492, the policy of Western governments has been assimilation, and it's incorporating the Natives into the white culture. And so, like for my people up in Alaska, we got a lot of Scandinavians that would come around and then would intermarry with the Native women. And then, so I have blue eyes, for example, and I have relatives that come from Norway. And we had Russian contact probably in 1750-ish. So we've been a lot of intermixing for a while. So tribes dilute as you go down each generation. Indians don't necessarily marry Indians because there's fewer and fewer of us. And so as you marry other people, it dilutes the bloodlines. Whole point being, please don't get caught up in the blood quantum concept. You know, Senator Elizabeth Warren got trapped by that when she said, oh, I have Cherokee blood, but she had no connection to the tribe, no enrollment with the tribe, no nothing. And so she got a lot of blowback for this, claiming this Native ancestry. when in fact, she really wasn't Native at all. She may have had a drop of Cherokee blood, but that doesn't make you Native. There needs to be more involved. And that could be, like, I go to culture camps with my tribe, and you learn the language, you learn the dance, you learn the history, the songs. That's how you become a Native, or you are a Native. It's not that just you have a drop of Cherokee blood. And interestingly, and people don't know this, Natives didn't become US citizens until 1924. We were citizens, and then Alaska Natives was actually a decade later. We were citizens of our tribes, but we weren't citizens of the United States. We were kind of this other, even though, what was it, the 14th Amendment or 13th Amendment back in the 1850s, there's 1860s, bestowed citizenship on those born in the United States. Didn't apply to Indian tribes. And so we're kind of the last ones to the table on becoming US citizens. An Indian tribe itself, I put up, it's a band of people. They're connected by religion, they're connected by blood, language, sort of social history. They have defined areas. For example, I'm Aleut. So if you go to the Aleutian chain in Alaska, there's 13 different tribes that are Aleut. And that's kind of what happened as the federal government tried to assimilate the tribes. They broke them apart. And so you'll have lots of different tribes in lots of different places, even though they're all really one bigger tribe, like the Aleut people in Alaska. But for today, if you're a tribe, the federal government, you need to be recognized by the US government. And there's 574 tribes that they recognize. And what that means is you get there's a certain relationship, government to government relationship between you and the tribe and the United States. Certain benefits are bestowed upon you. You have certain inherent rights, sovereignty, sovereign immunity, things like that. And there's some state tribes too, like California recognizes a certain number of tribes. North Carolina does. I think I have up there's about 64 state recognized tribes. Interestingly, for example, the Lumbee, you may have heard of them. They're in North Carolina. Heather Locklear is a famous actress who's a Lumbee member. They're a state recognized tribe, and they have tens of thousands of members. But for some reason, they can't get federal recognition. And it's a whole process you got to go through with the U.S. Department of Interior, and there's regulations, and it's very difficult to become recognized. And as an aside, I think that's because of Indian gaming. Since the 1980s, 1990s, we've had Indian gaming, and suddenly you've had groups saying, oh, we're a tribe, recognize us, and then we'll get some land, we'll put it in trust as a reservation, and we'll build a casino and make a lot of money. So the government has been very circumspect on who now is an Indian tribe, and it's become a much harder process. But generally, you need to be recognized by the federal government, and they can do that through treaty. The U.S. used to make treaties with tribes up until 1871. And then Congress stopped that. Executive order or federal administrative order, sometimes a judicial decision. A federal judge will decide, yeah, this really is an Indian tribe, or a tribe that got terminated gets reinstated. So it can come from any area of the federal government, but essentially you have to be recognized by the federal government to be an Indian tribe. And what they do is they publish a list every couple of years in the Federal Register, and they'll list every single Indian tribe in the country. And you'll have the Alaska tribes, which are like 220, 230 up there. And then the tribes in the lower 48, which is the other 400 plus or whatever. So you can look it up on this list in the Federal Register. Again, they're separate and distinct sovereigns. And the term you're going to hear, if you look in the Indian law cases, is domestic dependent nations, because we're not technically full sovereigns, so we can't enter treaties with foreign countries, for example. Only the United States can do that on our behalf. Or we can't go to war with a foreign country. Only the United States can do that on our behalf. So we have some aspects of sovereignty, but not complete sovereignty. I analogize this more to states. We're similar to states in a lot of ways, the things we do and the type of rights we have. And again, membership's determined by the tribe. So if your tribe, some tribes disenroll you, some tribes won't let you in, you really have no recourse but to go to the tribe. The federal courts won't get involved. The state courts can't get involved. You could go to Congress and try to get an act of Congress to enroll you, but I've never seen that happen. So really, you've got to resolve it within the tribe. There's some tribes that have if I've represented a tribe once, I think I had 2 members, Ramona Band of Cahuilla. I saw that the Augustine Band of Cahuilla, they're in Southern California. They have about a dozen members in the tribe. And then you look at someone like the Cherokee Nation, who we've all heard of in Oklahoma, and they got 730,000 members. So you have huge tribes, you have small tribes. You may ask why? Why such a big difference? Well, a lot of the tribes got wiped out as Western expansion in the United States, and especially here in California, the tribes in the Central Valley, the foothills, got wiped out because of gold mining, or the tribes here in San Francisco because the land was so precious and the white settlers wanted it. So a lot of the tribes got pushed into the state of Oklahoma, and the Trail of Tears out of Georgia. It's a long history, but suffice it to say that a lot of tribes were killed and they were wiped out, and so that's why you'll have some with very small numbers, particularly out here on the West Coast. Interestingly, on the East Coast, like the Northeast, there was a confederacy. It's called the Iroquois Confederacy, although that's kind of a French word. 6 Nations is really what they prefer, Onondaga and Tuscarora and some different tribes. They were never conquered by the United States. So the U.S. in New England kind of leapfrogged them and then kept going west. And so they have sort of a unique status amongst Indian tribes as never being conquered or never having entered a treaty giving up all of their land and their rights to the federal government. The reservations themselves all over the country, except Alaska, and I won't get into that, but there's a unique history there. But you'll have some tribes like here, the Iowa Band of Miwok Indians, which is out by Sacramento, California, doesn't have any land. They got re-recognized 30 years ago, but they have no land in trust, no reservation. And then you get someone like the Navajo Nation, who has their reservations as big as the state of West Virginia. And it's kind of Arizona, New Mexico, Colorado, Utah. So it just varies. And what's funny about the Cherokee Nation, and I looked at that 730,000 membership, that's actually bigger than 2 U.S. states. Wyoming only has, I think, 500,000 plus. I wrote this down. Wyoming has 579,000 people, and Vermont has 623,000 people. So the Cherokee Nation is actually bigger or more populous than 2 states. And Alaska is about 724,000, so it's about the same. So the number of people that live in Alaska is the same number that are citizens of the Cherokee Nation, it's really, we don't have U.S. senators, we don't have Congress people. So it's interesting, given our size, how little representation we have in the federal government. The governments themselves of tribes can be a general council, people 18 and older. Usually it's a tribal council. They elect 5 or 7 members who kind of run the government. It can be other forms. It could be hereditary. It could be a religious leader. It could be, some of the tribes will have a war chief and then a business chief. And so they have 2 leaders. It just depends. Each tribe is a separate sovereign. So each tribe decides its own government structure. And I'll get into this later, but interestingly, tribes aren't subject to the U.S. Constitution because we predate the U.S. Constitution. So that idea of separation of powers, legislative, executive, judicial, doesn't apply to Indian tribes. And so sometimes your tribal council will also be your president, will also be your judge. So it just depends. Each tribe they don't have to have a Republican form of government. But you'll hear those terms, tribal council, general council. Let's transition a little bit into kind of the dispute resolution systems of tribes, given the background. This is a very important case I wanted to highlight for you guys. Ex parte Crow Dog. It's a U.S. Supreme Court case. And what happened was, this is on a Sioux reservation in South Dakota back in the 1880s. Tribal member Crow Dog kills tribal member Spotted Tail. Tribal council, we got to do something. We got to resolve this dispute. We don't want the families fighting. We don't want a war within our own tribe. So the tribal council sits down with both families, and the tribal council resolves the dispute the way they've resolved it for thousands of years. And it's really a restitution-based system. And so they didn't punish like we would punish in the Western system Crow Dog for the murder. They just said, parties agreed, we'll do restitution, which was basically Crow Dog had to give $600, 8 horses, and then had to give a blanket to put over the crime to the surviving family of Spotted Tail. And parties agreed. And that was the resolution of that death. Well, the white settlers in South Dakota and the federal government were up in arms about this. This isn't acceptable. This isn't how we do it. And it turns out Spotted Tail was kind of pro-government, pro-federal government. And so he knew the local federal agents and they liked him, whereas Crow Dog was anti-federal government. We need to keep our way of life, et cetera. So the Fed stepped in and said, you know what, we're going to retry you, or we're going to try you ourselves. And so they arrested Crow Dog, put him in federal jail, tried him in federal court in South Dakota, convicted him, sentenced him to hang for the murder of Spotted Tail. He files a petition for writ of habeas corpus to the U.S. Supreme Court and says, wait a minute, they can't do this. I've already been tried, for a better word, by my own tribe, tribal council, and we've resolved the situation. The federal government can't retry me for this. Supreme Court agrees, I think 9-0. You're right. You can't. The federal government doesn't have jurisdiction to try an Indian for a crime against another Indian that was committed on the reservation. That's the jurisdiction of the tribal council or the people of that tribe, and they resolve it how they want to resolve it. Well, Congress gets wind of this and says, no, we're not going to let that stand. So they passed the Major Crimes Act of 1885, and they impose on all the Indian reservations around the country, I think it was 7 at the time, these major crimes, murder being one of them, that if this is committed on a reservation, even if it's Indian versus Indian, we, the federal government, are going to have jurisdiction, and we're going to prosecute you, and we're going to hang you. And so the U.S. government imposed its Western-style adversarial punishment-based legal system onto reservations. And so really, Ex parte Crow Dog is kind of a defining case in federal Indian law. It really highlights the shift in dispute resolution on reservations from sort of this traditional restitution-based historical context to more of a Anglo-American Western retribution punishment kind of approach that was imposed by the federal government. And we'll get into that a little bit later. So Ex parte Crow Dog, very important case, kind of defines what we're going to talk about. So today's system, the way most tribes are set up, you've really got, you've got a tribal court, and then you've got what are called peacemaking courts. And I'll discuss those. The tribal courts incorporate a lot of the Western concepts, and I'll explain why in a second. But if you think about Anglo-American dispute resolution, it's adversarial, right? It's one against one in a courtroom. It's competitive. It's highly structured. There's rules. There's a judge. There's a jury. There's a process how it works. You've got a winner and you've got a loser, and that's kind of the way our system is set up. It really focuses on the individual rights. What did the individual do? And it's really, if you step back and think about it, the Anglo-American system is a retribution punishment-based dispute resolution system, especially in the criminal context. You commit a crime, we try you, we convict you, we punish you. We don't necessarily think about the bigger picture, but we focus on you and we punish you. And I don't know where that comes from. I haven't done that research, but if I was guessing, maybe knights that jousted. I don't know. I don't know where that Anglo-American adversarial system comes from, and why tribal communities develop differently. So I always like to say the Western judicial system, Anglo-American system, focuses on the what. The what did you do? And then how are we going to punish you for doing that? Whereas the Native system tends to focus on the why. Why did you do that? And how do we fix it so it doesn't happen again? So Native systems, at least traditionally, were much more focused on the community as a whole. You lived within a tribe. And so how do you get along with other people in the tribe, given what you've done, whether it's a tort, a civil matter, or a crime, a criminal matter? You would, the elders or whoever would look at the community as a whole, and you're a part of that community, and how are we going to fix that? And so the relationships matter a lot. In the Western system, judge doesn't know you, victim doesn't know you, let's say prosecutor doesn't know you. They're just following the rules. They're going to convict you. They're going to lock you up. It's not that way in tribal communities. They tend to know who you are. know who your family is, and they're trying to find a way to fix all of this so you can live in harmony. And so restitution is sort of, that's kind of the cornerstone of Native dispute resolution is, okay, you did something to somebody else, so how are you going to make amends for that? And in the case of ex parte Crow Dog, he had to give $600 and 8 horses to the surviving family so that they could then continue to live. So it just depends on the context of the crime or the tort or whatever happened. But you're looking for a remedy that makes the other side whole or provides for the other side for what you've done or what you've taken away. And so it addresses it goes back to that whole relationship. You're going to have a relationship, if we're all living on a reservation, and they say there's 1,000 members, you're going to see that person, you're going to know that person. So how do you relate with that person going forward, despite what you've done? And I like to say native dispute resolution is kind of the why. Why did you do it? And then let's get into that, and then maybe there's a way to fix that so it doesn't happen again. And like I said, it'll take 2 forms, a tribal court, and then these peacemaking panels, they're called. And pre-1492, it was only peacemaking panels, and it was primarily restitution. Once Western culture was overlaid with tribal culture, you then started seeing this shift into kind of the Western model of dispute resolution. So let's talk about tribal courts first. Again, Indian nations are sovereign. They're their own governments, like a state or the United States. And so they can have their own courts, like a state or the United States. And so there's about 400 courts across the country. You may ask yourself, well, if there's 574 Indian tribes, why are there only 400 courts? Good question. And the answer is funding. Unlike states, which say are big and they, 500,000, 1 million members in the state, whatever. Tribes can't really tax their members. They don't have a lot of money. They don't have a big land base, a lot of them. So you don't have a lot of that revenue coming in to pay for courts. So either you get the revenue from the federal government, they'll give you a grant to set up your courts, or you're successful in Indian gaming and maybe use some of that money to set up your courts. There's a misnomer out there that every tribe is rich because we all have casinos, which is absolutely not true. Several states don't allow casino gaming, and so the tribes in those states can't game. And unless you're in a major metropolitan area, a little dinky casino in the middle of nowhere isn't going to make you any money. If anything, it'll have jobs for your members, but that's about it. So all the tribes aren't rich because of casino gaming, and so all the tribes don't have this slush fund to set up their tribal courts or other tribal programs. Most of them rely on the feds for a grant to set up their tribal courts. In federal Indian law, the general rule is tribes have a right to make their own laws and be governed by them. There are these sort of little separate sovereigns within the territory of a state. And the state law usually stops at the boundary of the reservation. So when you step onto a reservation, it's sort of like stepping into a foreign country, or at least a foreign state. And you may be subject to their laws and their rules, but the state law is going to kind of stop at the border there. And so the courts won't necessarily apply California law to resolve your dispute if you're sitting in a tribal court. There may be tribal law on point, there may be federal law on point. So that it gets complicated in that way. Generally, though, I would say, and I sit as a tribal court judge, both at the trial level and the appellate level, for the most part, you're going to find if you go into a tribal court, it's generally going to look like a state or a federal court. And I'll get to the reason why in a minute. But you're going to generally have a judge sitting up on a bench. You'll generally have an attorney from the tribe, 2 attorneys, a bench, a bar, and you'll resolve your disputes similar to the Western sort of conflict or adversarial model. So don't be frightened if you end up in a tribal court. They're not that different from state or federal courts. Most tribes will adopt usually the federal rules of civil procedure and the federal rules of evidence. Sometimes they'll adopt the state rules, but there's a clash between tribes and states oftentimes, and so they tend to prefer tribal rules, to the state rules. The judge may be wearing a robe. There's been a transition lately, but say 50 or 100 years ago, you might not have a law-trained judge. It could be an elder from the tribe, or the tribal chair would sit as your judge. And so, but over the last, at least in my experience, last 20, 30 years, tribal courts now tend to have lawyers as their judges. And whether it's me or someone else, some are tribal members. They have some judges who are not native at all, and they're just Western trained lawyers who the tribe hires to be a judge in their tribal court. And that brings up a whole host of problems or issues that I struggle with. For example, all of us that are trained in the Western system assume stare decisis is the way to go. You build on precedent and you look back at the prior opinions of prior courts. But is that necessarily the law of the particular tribe you're in? And keep in mind, there's 574 federally recognized tribes. Each is a separate sovereign. Each has its own law. So the law of the Navajo Nation is not the same as the law of the Cherokee Nation. They could have different deciding factors, or different burdens of proof, or certain crimes and not certain crimes. It just depends on each tribe. But as I come in as a Western trained lawyer, and I'm sitting as a judge, I have my own biases that way, that I'm going to slant towards or favor kind of the Western model, because that's what I've been trained in. And so I've noticed in the last decade or two, sort of the Westernization of tribal courts, with even native judges, but because we're trained in Western law schools, we're taught Anglo-American common law. And so you'll see a lot of that in tribal courts, in which there's starting to be a pushback on that with peacemaking courts. But so it's a struggle for me on does stare decisis even apply, or do I just make the decision based on the facts and the law before me, regardless of what's been done in the past? So issues like that come up. Most tribal courts are going to hear, if you end up in a tribal court for dispute resolution, it's going to be like a criminal misdemeanor matter. Remember, if it's a major felony, major crime, the feds are going to take that, and you'll be prosecuted in federal court. Probate, family law, some juvenile dependency stuff, those kind of cases end up in tribal court. In my practice, the more and more I'll do a big contract, a big financing agreement, and I'll try to get the parties to agree or stipulate to tribal court jurisdiction and venue. A lot of banks, a lot of lenders, a lot of third parties won't agree to that, because there's still a mistrust of the tribal court system, that tribal courts are in the pocket of the tribal council, and they won't be fair. In my experience, that's not been the case. And in my personal experience, I almost bend over backwards to make sure that the outside third party has a fair trial and a fair resolution in the tribal court, to try to dispel that myth or misperception that tribal courts aren't fair, or you won't get due process. That's not true. You will. And most or all tribal judges I've met try to be as fair as they can be. So please don't go into tribal court thinking you're already one strike down, because honestly, I don't think that's the case. You could have a single judge, you could have a panel of judges. Again, law trained, non-law trained, native, non-native. It just depends on each tribe. Some tribes, what they've done is called InterTribal Courts. And actually, I sit on an InterTribal Court, Northwest InterTribal Court. Tribes in the Washington, Oregon, Northern California, maybe Idaho, maybe Alaska. They'll pool their resources, and they'll have a body of judges who go to the different reservations to hear cases. It's like being an old circuit judge in the federal system. Now, when you go to a tribe, say I go to the Lummi Nation in Washington State, I apply the law of the Lummi Nation, whatever that is, to resolve that dispute. I don't apply the law of the Klamath tribes down in Oregon. So you may be a judge for different sovereigns, but you're only applying the law of that sovereign that you're actually hearing the case at. So InterTribal Courts, California has one too. It becomes an efficient way to do it, given the lack of funding. And so you may end up in, like in Southern California, it's called the InterTribal Court of Southern California. They might have almost 20 tribes now that are members. And so if you have a dispute resolution in tribal court, you're going to end up before this body. I think they have 4 or 6 judges. They're all law trained lawyers. They all know Indian law, and that might be the judge deciding your case. So it just depends. And I think as time goes on, you're going to get more of these intertribal courts. I just think they're a more efficient way of doing it. And then you have appellate courts, which I sit on. And again, keep in mind, a tribe doesn't necessarily have to have an appellate court. It doesn't even have to have a tribal court, to be honest. But if they do have a tribal court, they don't necessarily have an appellate body. Or if they do have an appellate body, sometimes it's to the general membership or the general council, which are all the members 18 and older. And that's where you would appeal your case to. So it just depends. And there's this concept called exhaustion of tribal remedies that the U.S. Supreme Court imposes, that the tribal court is the first court to determine its jurisdiction. If it has it, then you stay there. And if it doesn't, you can go to a federal court and get the case moved. But before you can go to the federal court, you have to exhaust. You have to do the trial level, the appellate level, whatever the review process is within that tribe. So keep that in mind. That if you end up in tribal court, you may also have to go through the tribal appellate court before you can have a federal judge look at whether the tribe even had jurisdiction over you. And I put in there tribal councils as the tribal court because that's come up a few times with me. Sometimes they don't have a tribal court or a tribal judge. And remember, because they don't have to have separation of powers, sometimes your tribal council will sit as your tribal court. So it just depends on each tribe and how it's structured its government. So keep that in mind, that the tribal council could also be the tribal court. And the jurisdiction's limited in tribes, and that's part of the problem. Again, the state law is going to stop at the reservation boundaries generally, and then on reservation, the tribe decides, tribal versus tribal member disputes that are on the reservation, and the state won't have jurisdiction. And the concomitant of that, or the counter of that, is off the reservation, the tribe will have no jurisdiction. So even if it's an Indian versus an Indian crime, if it's committed in the county off the reservation, then the state's going to have jurisdiction over that. So where things happen matters a lot. And then who's involved matters a lot. You have to be native to be tried in the federal court under the Major Crimes Act, for example. And interestingly, I'm one of the few people in the United States, or natives are one of the few people in the United States, we can be tried 3 times for the same crime. The U.S. Supreme Court's held that the double jeopardy clause doesn't apply because each of us is a separate sovereign. So I could be charged and prosecuted by the federal government, by a state government, and by a tribal government, depending on what happened and where it happened. I haven't seen that happen. Most tribes aren't going to prosecute you if the feds or the states prosecute you. But in theory, natives are subject to double jeopardy, which highlights another important point. If you're not native, you're generally not subject to the jurisdiction of a tribe. And that gets complicated depending on if you come onto the reservation and you do certain things on the reservation that say endanger or jeopardize the tribe. You pollute the water for the tribe or something. Then the tribe might have jurisdiction over you, or you enter a contract with the tribe, or you're employed by the tribe on the reservation. Then you've entered a consensual relationship, and they might have jurisdiction over you. But the general rule is that the tribes aren't going to have, the tribal courts aren't going to have jurisdiction over you for a criminal or civil if you're not a member of that tribe. So, but then who has the jurisdiction then depends between state law, federal law, and you have to look at U.S. Supreme Court decisions. And lastly, in this, I'll just say there's a law called Public Law 280 passed in the 50s that the feds took jurisdiction and they gave it to the states. So in certain states, California, Oregon, I think Wisconsin, Minnesota, Nebraska, Alaska, the state has criminal jurisdiction on a reservation now. So now the states can prosecute a native on native crime, whereas in most states they can't. So Congress ultimately has the power to decide if a tribe exists, to terminate a tribe, to say what that tribe's jurisdiction is. It's called the plenary power. Congress controls all. And so you are a tribe or you're not a tribe legally based on what Congress says. So in some of these states, Congress passed this law to kind of push the cost of criminal prosecution onto the states. And of course, the states said, they got the jurisdiction, but they didn't want to spend the money. So you ended up with a lot of lawlessness on reservations in these states, which then kind of was an impetus for these tribal courts to form. So at least the tribes can deal with the problems on their own reservation, particularly domestic violence. That's a big problem on reservations. And so that was an impetus to form these tribal courts because the states weren't doing what they were supposed to be doing in prosecuting these crimes. So generally, if you're not Native, they're probably not going to have jurisdiction over you unless, and then I listed a couple of the exceptions there. If you're an Indian, even if I'm not a member, I'm subject to their criminal jurisdiction. And then Montana is a case, US versus Montana. And then there's a couple of exceptions in there, but we're getting into the weeds. And then I just put up this tribal criminal court jurisdiction. This is in the non-public law 280 states. So this is most of the states in the United States. And you can see how complex this is or confusing this is. And so you got to look at what the crime is, who committed the crime, where the crime is committed. And then you'll figure out, well, can the feds charge you? Can the tribe charge you? If you look at the bottom and the crimes by a non-Indian without a victim, only the state has jurisdiction, even if it's committed on the reservation. So it can get very confusing. And then you add public law 280 onto that, which in like California gives the state criminal jurisdiction over the reservation. So it further erodes the tribe's sovereignty. So I'll just leave it at saying, if you have jurisdictional questions, do some research because it gets very complicated very fast. So, oh, and I'll just say this too, and I may have touched on this next one. Tribal courts have adopted the Western Anglo system. Well, let's step back a second. Tribes pre-existed the US Constitution, right? So we're not subject to the Constitution. So the whole Bill of Rights doesn't apply to an Indian reservation. So if you go to tribal court, you don't necessarily get due process of law, or you don't necessarily get equal protection of the law. Those are in the Bill of Rights. And so Congress passed the Indian Civil Rights Act in 1968 to kind of impose the Bill of Rights onto tribal governments. And they carved out some exceptions like the Establishment Clause, because some tribes are religiously based. And so their government is also their church leader, for example. So Congress carved out a few exceptions to that, and appointed counsel is another one. You don't necessarily get appointed counsel in tribal court. But what's important about all of this and the no Republican form of government, separation of powers and stuff, is that tribal courts don't have to have due process. And if they don't give you due process, you don't have a remedy, because Congress said your only remedy under the Civil Rights Act is habeas corpus. If they lock you up, then yeah, you can petition a federal judge to get you out of jail. But otherwise, you don't have a remedy. But what's happened is tribal courts will apply due process, and they'll apply the Western adversarial system because they want state and federal courts to recognize the judgments. I can enter a judgment as a judge on the reservation, but if you live off the reservation or you have assets off the reservation, I can't touch those. It's like going into a foreign state. I have to go to a judge of that county or that state and get an order recognizing my judgment in the tribe to then enforce, garnish your wages or lien your bank account or something like that. And the state and the federal courts are not going to honor my judgment in the tribal court unless it looks like the person was prosecuted or the civil lawsuit was handled as it would have been in a state or a federal court. And so de facto, tribal courts have had to incorporate state and federal processes to look like state and federal courts to get state and federal courts to enforce our judgments. And so it erodes our sovereignty and our traditional peacemaking, but that's what we have to do if we want our judgments to be honored and enforced off the reservation. So that's the reason why tribes have adopted the Western model in their tribal courts. It's so that the judgments can be enforced off reservation. Now on the tribal side, the peacemaking courts, that's the other side of it. There's tribal courts. Peacemaking courts of what have existed for thousands of years. And it's generally, today, they're coming back into vogue. Tribes are relearning the process. And it's a complicated history, but tribes got broken up and displaced. And a lot of the history was lost. Tribes tend to be an oral. You pass down your customs and traditions orally. And so a lot of that got lost. So a lot of tribes are reconstituting and restructuring and reforming their peacemaking panels or peacemaking courts. And this is becoming very popular. It's a voluntary process. You sit in a circle. You're going to have usually what's called a talking stick, which I have a sample here. This is a Navajo talking stick. And you'll pass it to whoever's going to talk, and only that person can talk. No one else can say a word unless you're holding the talking stick. And I think that's great, because I don't know how many of you have been in a courtroom where one attorney starts saying something and the other one jumps in, and then the judge is trying to say something. It's a mess. So it can be a talking stick. Some tribes use a certain religious bowl or some other artifact or ornament that's special or important to the tribe. And that's what you'll hold when you talk. So talking circles tend to have something like a talking stick. Tends to be in a circle, voluntary. You're all at the same level. You don't have a judge wearing a fancy robe. A lot of them will exclude lawyers, no lawyers involved. And you just sit and talk, and you try to figure out what's going on and how we resolve it for the benefit of the whole, the community, not just the person who committed the crime or broke the window or stole the loaf of bread or was driving drunk on the reservation, whatever it is. How do we help the whole community? So everybody takes their turn. The peacemaker is sort of the guide. And interestingly, the peacemaker is not necessarily neutral. He or she could know the person, the defendant, could be related to him. And that's part of the point. It's the moral persuasion. I know you. I know your family. I know what this is doing to your family. You need to stop, and here's why. And so it's not necessarily a third-party neutral coming from the outside. You're all trying to work together for the betterment of the tribe and the betterment of the community. And again, you're focusing on healing. You're not focusing on punishment. Oh, you did bad. Let's all come up with a punishment for you. It's, okay, you did bad. So how do we fix it? How do we help the community? How do we heal everybody? And that's usually going to be restitution is probably the main remedy for that, as opposed to punishment or retribution. And ultimately, you're looking at cooperation. You're not looking at the Western Anglo-American conflict. You're looking at cooperation and how do we all heal. And I'll be honest with you, as I've learned this in my past 10, 20 years, I much prefer the peacemaking process to the tribal court process. The adversarial process wastes time, money, and it never resolves the real problem, kind of the why. Why did it happen? And how do we make sure it doesn't happen again? The Western system is, you did the crime, we're going to lock you up. And then maybe you get rehabilitated in prison. Usually you don't. Come back out on the streets, and then you have recidivism. Interestingly, I looked at some statistics on this. For the tribes that do peacemaking courts, especially for criminal matters, their success rate is usually 90 to 95%, which means 90 to 95% of the defendants do not repeat the crime. It's a phenomenal success rate versus coming out of a state prison. I have no idea what the recidivism rate is there, but I've got to believe it's much, much less than 90%. So these things work. These peacemaking circles work. And again, next page, you're looking at the core values you're trying to discuss: honesty, humility. Keep in mind, many tribes are spiritual or religious, and so that'll work into the dispute resolution process. Again, you're focusing on cooperation. And it's similar to mediation, but it's not quite mediation, because we're not just trying to resolve this one case. How do we fix the whole? And so this doesn't happen again. So we're looking at the broader community, what's best for the tribe as a whole versus what's best for the individual. And fundamentally, that's the distinction I've seen between Anglo-American dispute resolution and tribal dispute resolution. Anglo-American is individual focused, and tribal is community focused, the group focused. And I personally think the group focus is so much better way of resolving than the individual focus. So to the extent more Western courts can incorporate this peacemaking model, I think the better off we as a society are going to be. And again, peacemaking is not trying to say who's at fault or who did it. They're just trying to find a resolution that everybody can live with. They're trying to reach consensus. And I end on this slide with the ex parte crow dog. Think about that case. That's exactly what the tribal council did in that case. They got the parties together, they had a peacemaking ceremony, and they resolved the dispute by restitution. And the federal government stepped in and said, no, 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 we're going to impose our Western adversarial model, punishment-based. So a lot of the tribes are trying to go back to that pre-ex parte crow dog style of peacemaking. So if you end up in the tribal system, you might go to a peacemaking court. versus a tribal court. But again, it's a voluntary process, so it just depends. And some tribes have them and some tribes don't yet. And then a subset of the peacemaking court is called an elders panel. And I've seen this in tribes where it's a group, usually 3 to 5 elders in the tribe. Tribes venerate elders. Elders are held in very high esteem. And so when an elder speaks to you, you listen and you do what the elder says. They've got wisdom, they've got experience. And this is how tribes have survived for thousands of years. And so usually you'll find this in sort of criminal misdemeanor, kind of a defer program, a diversion program. And the elder works with the individual, the teenager, someone in their early 20s, on what they did, why they did, and most importantly, how they harmed the community, not just the victim of the crime, but how did they harm the community? And then they teach them how to be a member of the tribe, to be an honorable member of the tribe, and help the tribe as a whole. And ultimately, they're focusing on the restitution, rehabilitation. Again, that's not punishment based. It's community based. It's how do we restore the tribe? So I'll end on this great quote from Sandra Day O'Connor. It was probably 30 years ago now. Indian tribal courts development of further methods of dispute resolution will provide a model from which the federal and state courts can benefit as they seek to encompass alternatives to the Anglo-American adversarial model. Even she saw that 20, 30 years ago. This adversarial model is A, very expensive, and B, may not be working as well as we think it is, or we think it should. And so I've seen things like youth courts. I've been a judge on a youth court here in San Francisco County, where a teenager gets a curfew violation or stealing from the school or something, and they'll get diverted into a youth court. I'll sit as the judge, but the whole jury is made up of other teenagers who've gone through the program, your peers. And you basically have to explain what you did and why you did it and why you're sorry for it. And you've got to write a letter of apology. And it's a lot like a peacemaking panel. I've seen state courts do drug courts, where similarly, you have to resolve your disputes. You're working on fixing the person as a whole, not just punishing them for possessing drugs and whatnot. So peacemaking, definitely the way to go. Definitely what I would recommend. It's a more holistic, cooperative, resolve the problem as a whole to help the community versus the Anglo-American adversarial punishment system, which I disagree with. So that's my presentation. Let me jump into the chat and see if a bunch came up.
In the chat, we have a lot of compliments and a lot of praise for what is an absolutely fascinating and wonderful presentation. And our custom here is to start on time and end on time.
Okay.
Time for live Q&A. Your presentation was so wonderful, though. I'm glad you took up the time with the prepared remarks. And you were kind enough to put your email on the slide here, so perhaps people could contact you privately with any questions they might have. Tom,
sure.
sweatherslaw.com.
Yeah.
Hope that people are able to contribute to the San Francisco Marin Food Bank in your honor, because raising money to help fight food insecurity is the vision with which Natalie started the Will Work for Food project and the spirit in which all of us continue it today. So with that, Tom, thank you so much for a fantastic presentation. See you next week with another great episode of the New Possibilities Hour. With that, we are complete.
Thank you. Take care.
Thank you. Fascinating.
Take care.
Thank you so much.
Email if you got questions.
That was great.
Thank you.
Mm.
Thank you.